Welcome back to the Blackletter Podcast. We set out to create an entertaining and exciting podcast about law and business. Blackletter, the name, comes from the Gothic typeset. Over time, Blackletter became the only font that English law books were printed in. It made it harder for kind of the common person to understand what the English law books said. Blackletter came to represent something that was law, that was set in stone, that was sort of old and a well-settled fundamental principle of law. We're here to demystify black-letter law. We're here to demystify things that happen in business and law and where those two meet. And I hope you have fun listening.
Welcome back to the Blackletter Podcast, listeners. I've got Tony Brown with me again. From Tech Search, Tony is going to, you've heard him on 2 episodes talk about what he does, patent monetization, a couple of war stories about the early 80s complex computer technology, one that went astoundingly poorly, but helped launch the company, and one that went astoundingly well, where he basically changed the lives of a widow, changed the life of a widow. And he earned the tagline, helping widows and orphans. I don't know about any orphans, but it's just, it doesn't work without the orphans, I think. Tony, welcome back. I digress. So distill for our listeners, as I said last show, kind of the wisdom of the ages. What are the 2, 3, or 4 things, whatever they are, that anybody who either owns patents and is considering talking to you about selling a patent portfolio to you, or talking to a lawyer, and how do they go about doing that? What are the important things they should know, and what should they do or not do?
The first thing I would say is, if you're the inventor, do your own research first and understand your patent, understand the patent history, which means going back and looking at all the prosecution history for the patent, and understand the products that you think it might apply to, and sort of understand what you've got there before you even go to an attorney. And if you're not the inventor and you just happen to own a patent, like the example of the secretary in my previous discussion, then you have to do that analysis with a good attorney. And you have to find someone who's experienced, who's been around the track a lot, and who's got a good reputation for not, for taking on cases that have merit. Unfortunately, in this business, there are a fair number of people who go around with patents that aren't particularly good patents, who are asserting them hoping to just get a settlement. You want to avoid that, because that's just not the way to approach it. I mean, you want to be comfortable that you have a valid patent that's infringed. Do your homework if you're able to understand it yourself, and if you're not, hire an attorney that understands patent law and the technology that's involved. You have to understand both in order to really assess the patent. And sometimes, you have to get an expert. I've dealt with, over the years, many experts in particular areas. I mean, you're not going to find any one patent attorney who understands every technical area, because it's just too hard. So sometimes you have to go out and find an expert, a consultant, who can say, well, I understand this field, and this is the way these products work. And some of these products are, really like black boxes. You really don't know how they work. It's really hard to, particularly in the computer areas. It's hard to.
AI patents, right? Those are literal black boxes. Even the developers don't know what goes on inside.
To parse these things out and figure out exactly how they work is very, very difficult. But, I guess advice number 1 is get a good attorney.
Okay. Do your homework, get a good attorney. So this
good attorney. The second thing is, it's always good to have multiple patents. If you're going to be asserting them against an infringer, you don't want to have to rely on one claim of one patent. It's just like going hunting with one bullet in your gun. Okay, you want to have a 6-shooter, or something like that. You want to have a bunch of different patents if you have them, or at least a patent with a lot of different claims. And the other thing you want is ideally to have a continuation on file, so that as you learn more about how products work, assuming that your written description covers it, you can add claims to your patent. and you can have new patents issued that have additional claims that might apply to developments in the technology. Um, so that's my second piece of advice is to make sure that you have sufficient claims or patents that cover the particular products involved, and ideally have a continuation on file so you can have new patents issue as products develop. So my third piece of advice is if you're prosecuting a patent, if you're in the stage where you got a pending application, you're trying to get a patent issued, and you have, usually you have a prosecution attorney who's handling it. But I find that, and particularly when I went to enforce patents, it was very frustrating to me that the people who wrote the claims were largely ignorant of the English language. I'm put it in a nice way. They would write claims that maybe an engineer understood, but that the average person couldn't figure out what they're saying. And at the end of the day, when you enforce these patents, you're going to be if you get to a jury trial, you're going to have a jury of people who are not technical people or lawyers. They're going to be people who work at banks and postmen, and the guy down who works down
Right?
the block from you. They're going to be people like
You don't have to explain it to them.
and you
Yeah.
got to explain it. If the language of the claim is so convoluted and the sentences are like, page after page without punctuation, and it's written in engineering language, it's really hard to explain this stuff. And then you have to get into claim construction. You have to hire people to come in to tell the jury what these words mean, what these sentences mean. And if there's any way at all, you can write these claims in plain English without using highly technical terms. Do it.
So much the better.
So much
Yeah.
that it makes your life a lot easier, right? I mean,
Tony, what is a plaintiff's favorite sentence at a Markman hearing in claim construction? I think it's plain and ordinary meaning. I think that's like every case I've ever done on the P side of a patent
right,
case.
right.
We want plain and ordinary meaning, and the defense always wants a very technical description of what the claim is.
No,
So I think that speaks to everything you said.
I mean, I would get involved in my, particularly when I had patents with continuations, I would get involved in the pending applications. I would actually write some of the claims because I was not happy with what I would read the claim and say, I don't understand this. I mean, I'm not a technical person, but I've been doing this a while. I don't understand this claim. I don't understand what this says. And I would rewrite it in a way that I understood. And I figured, okay, I'm not a tech. I was a French lit major. So if I can understand this, then the average guy in the
It-
jury is going to understand it, and if I can't understand it, then the judge sure isn't going to understand it, because
yeah.
he's not a technical person. So
So
that's my third piece of advice.
So if I were to summarize then, first piece of advice is do your homework and get a good lawyer. Kind of hand in hand. First piece of advice is get the background right. Second piece of advice is that you've got to understand what it is to have a good patent. That it's not obvious, that there isn't prior art, that you have more than one claim, that you have multiple patents. Don't go hunting with one bullet, right? Make sure that you've got a strong and lots of ammunition so that you can be successful in the field of hunting, I guess, in the field of prosecuting or pushing forward asserting patents. And then your third piece of advice was make sure, if you can, and this is precedes everything else, that your patent is written in such a way that it's easy to understand. I think it's hard if you already are stuck with patents, you're stuck with what you're stuck with, but maybe in your continuation, or maybe as you think about it as an inventor and you read what a patent attorney sent you and say, wow, I'm the inventor, this is confusing to me.
Yeah.
You need to go back to your patent attorney and say, hey, this needs to be understandable. So I think that those are great three pieces of advice. Final question for you, Tony. Favorite piece of French literature?
Victor Hugo, or The Hunchback of Notre Dame. I mean, that was a good book.
Fantastic. I mean, if it was your major, I had to ask for
Yeah.
your 10 cents, but everybody should go out and buy and read in French.
Albert,
Not the Disney version.
Albert Camus, this L'étranger, The Stranger. That's a little dark, but it's a great book.
Yeah, I wouldn't advise anyone to start with Camus if they're diving into French literature and French.
Yeah.
But yes, interesting book and seminal. So excellent. Well, thank you so much for joining us, Tony. It's really interesting and really fantastic. And we'll put your kind of information if people are interested or have questions for you about patents on our podcast, so they can reach out to you as well. And I just want to thank you for coming. It was really great to meet you. I'm so glad you have been able to work with two of my favorite law partners for 20 years.
Yeah.
And that you like those guys, because I really like them too. I think they're also, I agree with you, two of the most brilliant patent litigators we have in the country. And thank you all for listening to this episode of the Blackletter Podcast and joining Tony and I these last 3 episodes. Download us wherever you get your podcasts, watch us on YouTube, and we'll catch you next time on the Blackletter Podcast.
That's all for today's episode of Blackletter. Thanks again for listening. Join us next time when we talk about more Blackletter issues in creative ways. Make sure you subscribe to the podcast so you never miss an episode, and check out our website at blackletterstudios.com.